So welcome everybody to this webinar today, How Can Realtors Avoid Getting Sued? My name is Romy Jurado. I'm an attorney here in South Florida. I've been an attorney for over 10 years. I practice in different areas of law. I focus on everything having to do with business. We do business litigation. In my firm, we also handle business immigration, probate, estate planning, and we serve as a resource to realtors. I'm happy to say that I have helped many realtors either avoid litigation, deal with litigation, find ways to come into settlements and just overall, protect themselves. There's also a lot of ethical issues that are going on right now. Either your clients or your, people that you dealt with can file an ethical complaint in front of the Miami board or the Broward board, and we have been able to help in those as well. So today's class, I would like to make it really interactive. There is a Q&A and there's also a chat area. Please feel free to post any questions. I'm going to try to answer them all so that you can get as many answers from today's webinar. If you have any questions in regards to litigation and everything like that, just let me know. Okay, so let me go ahead and start by sharing my screen. 1 second. Alrighty, so everybody should be able to see my screen now. Again, my name is Romy Jurado. I'm an attorney at Jurado & Farshian. And as I was telling you, we practice in the areas of business law, real estate law, immigration, probate, estate planning, and litigation, which is what I'm going to talk to you guys about today. So real estate agents are frequent targets for lawsuits. A common lawsuit scenario involves, for example, the buyer of a property suing the seller and the seller's agent for failure to disclose defect in the property. In some cases, the buyer also sues their own agent to the transaction. The lawsuit alleges not just negligence, but also alleges that the seller and the agent conspired to keep defects hidden to facilitate the sale at a higher price and earn a higher commission. I have seen this before. Now, I know that you guys are familiar with the as-is contract. That's the one that we usually use here in Florida, in South Florida. But what happens is the buyer ends up buying the property and they move in and they start seeing all these things that they didn't see before or that they didn't realize. For example, there was a roof leak that they didn't realize was there, and then it started pouring and water started coming out. There was an issue with the electricity and they didn't realize before because I guess the inspector just went and tried a couple of things here and there. But then when they're actually using the kitchen, they realize that there is, really bad issues with the electricity. And what do? The buyer is like, well, I just bought this property. My realtor made commission on it. My realtor should have told me, da, 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 da. So they either sue their own realtor, or they also can sue the seller's realtor, right? Along with the seller, they can sue everybody. Why? Because in a lawsuit, what an attorney is going to try to do is find as many deep pockets as they can. So if they can find liability here, there, everywhere, they're going to file a lawsuit. And you want to limit your exposure as much as possible. If you're representing a seller, the key is disclose, disclose, disclose. Have the seller prepare that seller disclosure document. Don't prepare it for the seller, okay? It's very important that you don't prepare it for the seller. The seller needs to prepare the disclosure document. If they don't understand English for some reason, then have them hire an attorney. I'll gladly sit with them and explain to them what it says and have them prepare it. Why? Because what's going to happen is they're going to have you prepare the seller disclosure. And then when things go bad, they're going to say, well, that's not what I meant to say. My realtor did it. She did it. She failed to disclose. I told her about this and this and that, and she decided not to put it in the seller disclosure because it would kill the deal. I have seen that happen too. So if you're representing the seller, have the seller prepare the seller disclosure. Do not prepare it for them because you're assuming liability. You don't have to. And then tell the seller it is your duty to disclose. Okay, it is. Even though it's an as-is, you have to disclose everything. If you're on the buyer side, very important. Have the buyer read the disclosure. They have to read it. It's not just a form that a formality, okay, sign it. No, I have even seen contracts where they make the buyer sign the seller disclosure like right there and then with the offer. No, Don't do that. Have the buyer take their time, read the seller disclosure, understand what it says. If they have any questions, unless you are a contractor and you can explain to them how much things cost, don't even answer those questions. Point them out to a contractor that will tell them, what it would cost to fix. If they mention something, if they see a disclosure that says, oh, there might be wetlands, have them hire the right company to find out if there are or not. If you see something, an issue with the electricity, have them hire an electrician to go look. Now, clients are mistaken and they think, well, I paid for an inspection. The realtor told me to get an inspection. The inspector went, and now I should be able to sue the inspection company because they didn't find this. It doesn't work that way. If you read the inspection from the inspection report, it's going to have a bunch of disclaimers. So just because they do an inspection doesn't mean the inspector is going to be liable. They're not. What the client needs to do is, one, read the disclosure that the seller signed to make sure that nothing is disclosed there that raise any red flags. If they do, they need to hire the appropriate professionals. An inspector, it's needed, but they need to hire a contractor. They need to hire people that actually do the work so they can know what it's going to cost and what it would take. Don't give them advice as to what you think it's going to cost. Do not say things like, oh, no, that's not, it's not really a leak. It just needs paint. You're assuming liability. It's just not worth it. Okay. So if you're representing the buyer, have them read it, have them understand it. If they have questions, have them ask the professionals. They need to read the inspection report. They cannot, and I have seen this, OMG. They send it to the realtor, like, please look, it's like 20 pages. Look at it and let me know if there's something wrong. Don't do that. They need to be the ones reading the inspection report. They need to be the ones reading and signing the disclosure. Why? Because you don't want to be given extra liability. Your job is to find them the property. Their job is to do their due diligence to see whether they want to buy it or not. Okay, so just be careful with those things. All right. So because this type of lawsuits, they're very common because that's what happens. They get the inspection done, they go to the property, there's issues, and they will try to go against whoever they can to recuperate whatever money they can from what happened. And if they can find liability on you, believe me, they will. So you want to limit your liability as much as possible. If you're on the buyer side, you want to say they signed a disclosure, they reviewed their their inspection, and it was up to them to decide whether they wanted to continue and investigate it further. I made no representations as to the status of the property because you're not a contractor. Unless you are, then that's a different story. All right. I think I have a question regarding that. Let me see. What if the seller won't fill out, especially in a rental situation or fix and flip? This is not a required document, and numerous agents have pushed back when asked for it. Put it in writing. You're buying this property. The seller has not filled out a seller disclosure. You understand that there might be issues with the property that we just don't know. This is an as-is contract. You're taking it as is. If you want to buy it, feel free, but I cannot give you any representations as to the status of the property. Limit your liability as much as you can. If you can put it in writing, then put it in writing. All right, let's see. All right. Know the relationship you have with your client, right? So you're required to explain the nature of your relationship with all parties involved. So we have transaction broker, single agent, no brokerage relationship, client versus customer. So most of us defaults to transaction broker, which basically means you represent the transaction. You're not representing the buyer as a fiduciary or the seller as a fiduciary. You represent the transaction. That's what it defaults to, unless you tell the people otherwise. If you tell them otherwise, or if you make them, they sign something that says otherwise, then you're going to be considered a single agent. And I don't recommend that you become a single agent. Why not? Because you become a fiduciary. So what is a fiduciary? A fiduciary is like an attorney. So me, I have to look for the best interest of my client, even if those best interests go against my own interests. And if I cannot adequately represent the client because it goes against my own interests, I have to withdraw from my representation. Otherwise, I'm violating ethical duties and I'm putting my license at risk, which I will not do. That means I can only represent the buyer. I can only represent the seller. I need to fully represent the buyer from representing the buyer and look out for their best interests at all times. And in your case, it would mean even if it goes against you getting paid, against your commission, you are basically let me see, how can I put this? You are not their attorney, but you have the same relationship to them as that, and you owe them the same duties. So no, I wouldn't advise you to become a single agent unless you fully understand the ramifications of becoming that. If you're a transaction broker, that's what it defaults to. Usually you get them to sign something that says that you're a transaction broker if you want, so that it's clear on both parties what your duties are, what you have to do. If there's a no brokerage relationship, absolutely, they need to sign something. They need to sign some waivers. Otherwise, it's going to create problems for you. So just a little outline of how I see things whenever we're dealing with any type of representation or anything that you're doing within the real estate arena. It's you have to know what you're doing, protect, and then we plan. Okay, so you have to understand your coverage. A lot of people come to me and tell me, Romy, but I have E&O, I have errors and omissions insurance. Doesn't that cover me against some things? It doesn't cover, E&O covers against some things. And depending on your policy, it may cover you more than it, or it may cover you less. And you may have some liability protections within your coverage, some commercial liability. You know, I don't know what insurance you have, but it's essential. It's the most important thing that you know what insurance you have. Not what the insurance agent sold you, meaning, oh, you're going to be protected. Don't worry about it. Everything is great. No. You actually have to read your policy, and I know it's boring. It's a couple of pages or however, and you don't want to read it. Then hire an attorney to read it for you and send you a summary. You have to, especially if you're a broker, okay, especially there, because now when you're a broker, you're not only liable for your own rowdy doings, you're liable for all of your agents' rowdy doings. A lot of liability, like crazy. So if you're paying for insurance, you want to make sure you have adequate insurance, and you want to know what it covers and what it doesn't cover, okay? So for example, common claims that we see made against real estate professionals that we are either defending, we defend a lot of realtors, brokerages, or we might be making them because we represent the buyer of the property, you know? So knowledge is power. Again, failure to disclose is one of them. Clients who discover defects after signing the papers will be quick to blame the real estate agent. Yes, because clients think that everything is your responsibility because you're making this commission. So therefore, they're going to hold you responsible. They don't understand the difference. Every damage and every defect found on the property should be fully documented. Defects can include construction issues, leaks, noises, improving without permits. Very important. A lot of people are making constructions and things like that. That needs to be disclosed in the seller disclosure. If you know something, then you have to disclose it. So be careful. And we could analyze that, when you have to disclose, when you don't. When a client sues a real estate agent for failing to disclose a property defect, they must prove the agent knew or should have known about the defect. If you know of a defect, you got to disclose it and then not disclose it. Okay. Be sure to perform a thorough inspection of the property and have your client sign statements that documents their awareness of any issues. If they don't sign it, it didn't happen. If you told them verbally, it didn't happen. It has to be in writing. And if they don't sign it, at least send them an email. Memorialize your conversation. Hey, Peter Pan, as you know, I sent you the inspection report, and there's some issues there that I asked you to please look at, especially page this, page that, whatever. In any way you want to put it, just make sure that you're putting the responsibility on them, okay? Because you don't want them to come after you. So you want to make sure that they understand, and they probably won't even read it, but at least you're limiting your liability. Today's class is about limiting your liability as a realtor. I'm not talking to you as I would to a seller or to a buyer, because that's a different story, right? So today's class is about limiting your liability as a realtor, as a broker, everything like that. So if you're a broker, you need to be training your agents. You have to tell them, like I tell all my clients that are in business, everybody and their mom, whenever you go into business, it's as if you're standing on I-95 and you're standing there and cars are going to come at you. They're eventually going to hit you because you're there, right? So you want to limit your liability as much as possible by building some type of wall, by having all these disclosures, maybe working under a PA, a professional association. You want to do as many things as you can to limit your liability, okay? It's essential. All right, breach of duty. This represents one of the most common lawsuits against real estate agents. You know you must always act at the best interest of your client, as clients place a special trust in real estate agents for your expertise. As a real estate agent, you're held to a higher standard of honesty and full disclosure. Any breach of this duty, whether for negligence or intentional action, subjects you to risk of a lawsuit. Always document everything and be honest at all times. So if you breach of duty can be anything. Like my agent didn't present this counter offer to me because they wanted me to accept this other offer that was by one of their buyers. So, it could be anything. Always act ethically. Present any and all offers. If you have any duties, depending on the type of relationship that you have, make sure you fulfill them. Put it all in writing. The other time somebody asked me, Romy, the seller is telling me they don't want to see all offers, only if they go over a certain amount. And I told them, no. Present all offers, send them to them. They don't have to open them, but then they can never come after you and say you didn't present all offers, which is a duty. Other things that I've seen, for example, is it okay to negotiate a higher commission? It could be okay as long as your client knows about it. If you tell your client, hey, client, listen, this property pays only 2%. It's not worth it for me to show you because I'm not going to make any money. So do you want to pay me the difference? And they'll say, no, yes, show it to me. Or they can say, ask the seller to pay you the difference. The client is asking for that. See, that's a different story than if you just simply send the offer, put the number in and see if they get it or not. So you have to make sure that you negotiate these things with your client. At the end of the day, you shouldn't do work that doesn't pay you commission, that you don't make enough money. But at the same time, everything has to be disclosed to your client, and it always has to benefit them, in order to be able to work with you and for you to be able to do things ethically. All right, breach of contract, right? So breach of contract is you broke the contract. This happens in real estate settings. This happens in business settings, all over the place. When a client claims a real estate agent did not perform under the terms of the contract, it could be your listing agreement or whatever agreement you have with them, you need to seek legal action. One of the most common reasons for breach of contract is failing to comply with timeframes stated in the contract. A breach of contract claim is often made in conjunction with claims of negligence, fraud, or breach of duty. It is important to examine every aspect of your contract with an attorney to ensure that all appropriate information is accounted for and adequately. Always, additionally, be sure to take time with each client to advise them on the terms of the contract. And if there are any unclear clauses, terms, they need to ask you questions, or they need to be represented by an attorney before they sign. All these things that I'm mentioning, these legal causes of action, let's go back a little bit. Failure to disclose, breach of duty, breach of contract, they likely are not covered by your errors and omissions insurance. So read your policy, because they may not be. Negligence, for example, this is a cause of action alleging the failure to exercise due care towards others that a reasonable or prudent person would under the circumstances. Clients can make claims that a real estate agent should have known something but did not and failed to take appropriate action. Negligence differs from fraud in that it lacks an element of intent. Often clients seeking legal action will begin by claiming fraud, because fraud requires that you really prove the person knew. But if they're unable to prove intent and that they had the intent to defraud you, which is difficult to prove, they can start with that action, but then when they're not able to prove it, they will seek reparations for negligence. It's hard to prevent claims of negligence because you might not always know what you should have known, right? So be sure to obtain insurance coverage for these unfortunate circumstances. So read your insurance and make sure that it covers you. Bodily injury, yes. Realtors can be sued for bodily injury because you're the one that brought the person to the house and they were injured in the house. They're going to sue the property owner as well, but be sure they're going to sue you too. So if a client is injured during a showing and you're found liable, you'll be responsible for reimbursing any costs related to the accident. Always make sure any debris is picked up. Bodily claims might also include physical problems resulting from an undisclosed mold problem. You took into a place for a mold, for example. Evaluate your property for all possible physical risk and protect your business with insurance for unforeseen accidents. Yes, you can draft waivers to limit your liability. We do those all the time. They have to be written in a special way. The law is always changing. So don't just copy and paste something that was written for something in another state or something that was written a year ago or 2 years ago, because the law on waivers, how you can release liability, is always changing. I'm telling you because we see it all the time. So yes, you can draft waivers. You can have your client sign stuff. Will they sign it? I don't know. You tell me. They're your clients. But it is something that I advise, my brokerage, I represent various brokerages as their attorney. I advise them to do, to try to limit their liability as much as possible. This is weird. We live in a very litigious society. Now, I love this country and I love the law, and this is the reason why I went to law school. But the reality is we do live in a very litigious society. Everybody's trying to see who they can sue. So you have to protect yourself accordingly. Failing to keep client data secure. Be very careful with this, right? So you are the agent, the client is giving you their bank statements, big issue. I understand that you're trying to help your clients to get loans, and that's all great. And we want you to help your clients because, we want to close. We as a title company as well want to make sure that we get to the closing table. And I know how it is. I bought property myself. I know the banks want blood. And so your client gets frustrated and you're there trying to help them. The problem is when they're giving you the information to send to the bank, now you're responsible to keep their taxes secret, to keep their bank statements secret. And if there's any breach or anything, guess what? They're going to hold you responsible. There are softwares that clients can use to upload things to the bank. There is, ShareFile. That's a secure thing that we use. The banks also have their own secure portal. I mean, the client needs to do this on their own. If they're putting you to do this, you're assuming extra liability that you don't have to assume. Or they can be represented by an attorney and then the attorney can handle it for them. We do that all the time too, especially for foreigners. People don't want to keep things secret because their life is, might be at risk. Then they need to hire an attorney. This is what they have to do. Don't assume that extra liability because then you're going to be responsible to keep their data secure. And everybody's getting breached left and right. So hackers are everywhere and they want your client's information. Yes, they do. If they're successful in getting it, you will be the one who pays. Simple. If they give it to you. So protect your client's information from criminals by installing security software and keeping your paperwork in a secure location. Once you have a secure system in place, regularly change your password and make sure your data is encrypted. That's at the very basic. If you could avoid being the one in the middle submitting that information, that's what you should do. Wire instructions. This was rampant before. I have seen a decrease now. Please don't be in charge of giving your client wire instructions. Why not? Because then you're assuming that liability. Have the title company, law firm, give the wire instructions directly to the client. We give the wire instructions to the client through a secure link. So it's not even a PDF attachment to an email. No, it's not, because that can be hacked. So we send them a link. They can download the wire instructions from them. And then they have to call us to verbally verify the wire instructions. They're not allowed to wire money unless they verbally verify with us here in our office that those are our wire instructions, because we're handling a lot of money, right? And hackers, this has happened to a bunch of title companies, law firms, big businesses. Barbara Cochran, if you guys know who she is from Sharks, this happens, okay? People they're like all day, all they're doing is trying to see how they're gonna hack you. And we are an easy target because we always get money in, money out. So if you can avoid being in the middle of giving and receiving wire instructions, by all means, do so. Put the title company to work, put the law firm to work. We will gladly do it. We will send it to your client. We will send it via WhatsApp. We'll send them a secure link. We'll do whatever it takes to get the information to them. You shouldn't be acquiring that extra liability, because when something goes bad, they're going to blame you. Don't doubt it. And come after you legally, of course. All right. Oh, yes. And again, I don't think this is covered in your errors and omissions insurance because that's not even part of your job. So be careful with that. Misleading clients. Every real estate agent strives to make their property stand out from the crowd. That's all great. It might even be tempting to exaggerate here and there about the features or the condition of the house. However, this kind of deception can end disastrously for agents. If a buyer feels misled about anything, a lawsuit typically follows shortly after. Always be truthful about claims you make about the property with no room for misinterpretation. A misleading statement might help you close a sale, but it might also lead to legal action and financial loss. It's not worth the risk. Not just verbally. I've seen it a lot where agents will use not actual pictures of the place, but enhanced pictures, and they don't disclose that, and that's a no-no. So if you're a listing agent and you're using enhanced photos, disclose it. If you're a buyer's agent and you realize those are enhanced photos, let your client know. Just be careful, avoid liability as much as possible. Don't misrepresent something you don't know. Don't say, yes, they're going to build this beautiful shopping center area in a couple of years, and there are already plans for it. I mean, if you don't know that, you're just lying. Don't do that. So be careful. You don't want to be sued for misleading clients, okay? And again, that's probably not covered in your E&O insurance, so you may want to check that. Representing clients in unfamiliar territory. If you're showing and selling properties in an area that you're unfamiliar with, take extra precaution and research first. Many times there are requirements or other situations particular to an area of which you might be unaware. If an issue arises that is due to geographic location, you may be the one to blame because you failed to warn your client about any such problems. Just become familiar. I'm not saying you cannot show places. You can only show Miami. No. Just if you're going to go into a new market, become familiar with the customs. What do they need to do? For example, if you're showing property in El Portal, we have this thing that they need to get a certificate of occupancy. So if you're showing them a reoccupancy, if you're showing them a house that has a bunch of illegal additions, guess what? They're not going to be able to close because when the inspector comes to inspect it, they're going to see all those illegal additions and they're never going to issue the certificate of reoccupancy. We have that in City of North Miami as well. We have that in City of Hialeah. We have that in City of El Portal. And so every city might have its own particularities. And if you're going to start selling in that city, you just want to become familiar. That's all. I'm not saying don't do it. Just become familiar. Giving legal advice. This is a big no-no. No, don't give legal advice unless you're a licensed attorney in the state of Florida. Then you can't. Clients want the real estate agents to have an answer for every single question they ask. And real estate agents always want to help their clients. Just remember that it is considered illegal for a real estate agent to give tax or legal advice. This mistake is especially difficult to avoid because taxes and legalities are an unavoidable part of real estate business. Give the wrong advice and the client will blame you for any consequences. Instead, politely request that your client direct any questions to me, an attorney, or to a CPA if it's tax related. I don't even like to give tax advice. I try to push them to the CPA. This is very important, okay? It's actually unlawful, illegal, a crime to give legal advice when you're not an attorney, but you're also buying yourself extra liability. So just put them with the attorney. If it could be me, it could be somebody else that you work with. I would rather it be me, but it's your choice. Just, have them do their job and advise your client so your client is fully represented. There's so many different areas of law that are involved when buying real estate. It's not just, for example, real estate, right? Especially in South Florida, we deal with a lot of foreigners. There's FIRPTA issues, it's a special withholding. There is estate planning if they're foreigners and they die and their estate is subject to a huge state tax, 40%. There's just so many issues, liability, how do we avoid liability, that there's never a one answer for every single case. It's always an analysis of the client's particular situation to see what they want to do, what are their goals, what are they afraid of, how we can work around to devise a plan that works for them, legal-wise. And then tax-wise, there's always things, that they need to address with a CPA. As the realtor, don't recommend that you give any of that legal advice or tax advice. Have people as part of your team that you can talk to, that you rely on, that can work with you and help your client out. Be seen as a resource like, oh, yes, let me put you with this attorney. Let me put you with the CPA. Introduce them. The client is free to go wherever they want. But don't answer those questions, even if you think you know the answer. Why? Because the law is always changing. And you don't know the answer. We always have to research and see what's going on, and you don't want to acquire that extra liability. Okay, so no giving legal advice. Have good, reliable professionals that you can refer to and work with. Okay, let me see. Protect yourself. Oh, let me see. I think we have some in the chat, but I'm not able to see the chat. I'll look at the questions in the chat in a minute. Okay, protect yourself. The common failures that lead to lawsuits, more lawsuits. Today, we're all about lawsuits. We talked about the failure to disclose. A property defect can lead to a lawsuit. We have seen it a lot, so be careful with that. Defects, right? I mentioned defects before. What type of defects am I referring to? This can include violations, permit codes, water issues, structural issues, wiring and electrical issues. Have them be advised by by a contractor that deals with that, right? So for example, for the permits or code violation, the inspector must make sure that the property is in accordance with the county regulations, imposes no updated and requires no permits. We do a lien search when we close on a property. The lien search is sent to the city and they tell us if there's any open permits, or the county if there's any open permits for that particular location. If there is, the as-is contract doesn't require the seller to close them. So we always like to add additional language requiring the seller to close any open and expired permits and to remove any and all liens. We always like to add that language there, because otherwise now you have a deal. The buyer says there's an open permit. The seller says, I don't have to close it. And now your buyer's like, oh my God, what do I do? Well, technically they cannot come after the seller because the seller doesn't have to close it. So it turns bad. So we always like to add that language. Let's see. What type of defects must be disclosed? Any defects that materially affect the value of the property must be disclosed. These defects include, but are not limited to, condo HOAs, renting and selling, views, constructions, FHA qualifications, ban worthiness of community, all these different things. Be proactive. So address timely your client's concerns and complaints. Understand your duty to each party. Make sure all necessary parties sign the contract. Understand who the parties to the contracts are. Name change, assignability, properly identify the parties. Your client should consider tax and state planning. One thing regarding parties to the contract, and this I have seen in lawsuits as well. If you're dealing with a trust, make sure that the person that signs the contract is the trustee of the trust on behalf of the trust. That's very important. Otherwise, you don't have a binding contract. If it's just signed by somebody that says, oh, but I'm the beneficiary, no. The trustee of the trust needs to sign the contract. The trustee of the trust needs to sign your listing agreement as well. So if you're going to go sell a property that's titled under the trust, make sure that your listing agreement is signed by the trustee of that trust. How will you know? They have to disclose it. You'll see it in the property appraisal's office who the owner is, but they have to tell you who the trustee is. It should be named there, and you want to make sure that you get that. Deadlines and all milestones. Remember that the deadline to obtain financing, it's not tied to the closing deadline. A lot of agents, they get an extension for the closing date, but they fail to get an extension for the financial date that they need to have the loan pre-approved or approved for. So you want to make sure that you extend both, because there's no, I mean, your client is able to close later, but they're not able to get the loan, they're still going to lose their deposit if the financial contingency wasn't extended. So you want to be really careful. What I advise my agents to do is send an email, say, dear client, your loan contingency period expires this date. You either need to cancel the contract and get your deposit back, or we need to ask for an extension to this other date. And if the seller doesn't want to extend, then dear client, the seller doesn't want to extend. You can either cancel the contract or continue, but understand that your deposit might be at risk. The only time you could always get out is, depending on the contract, of course, is if the appraisal comes down lower. Otherwise, if you're no longer subject to a contingency, a financial contingency, and the person doesn't get the loan, regardless of the reason, their deposit might be at risk. So you want to make sure that you send those emails out so the client makes a decision. Yes, cancel the contract, or no, I know I'm going to get the loan eventually, even though the bank's taking forever, and they are taking forever. Failure to perform final walkthrough prior to closing. Please do your walkthrough. Many things can happen, especially right now. You go, you buy the property, you saw it, they did inspection. They're like, oh no, we don't want to do the walkthrough. It's okay, I just want to get the property. No, it's not. Because now when you go and occupy the property, you see that there's squatters there, you see that there's issues there. And now what do? You already bought it. Assign leases, very important. People end up closing, and then the lease it's a residential lease is with the previous owner, or the commercial lease is with the previous owner. Yes, you became the new owner, but now it's a whole issue if you want to sue those people to either evict them or for payment or whatever it is. And you don't even know, because the lease may say that you are holding 0 deposit or 10,000 deposit, but then when you go talk to the tenant's like, no, they're not, they're holding 20,000 of my deposit. My rent, even though the lease says is $1,000, I'm really only paying 500. So you want to, at closing, obtain, well, not you, the title company, the attorney should obtain a stopple from the tenant, which basically says, I'm the tenant, I pay this amount per month. I acknowledge that landlord has this amount of my deposit, these are the terms of my lease, something. So that way you're able to come after a tenant if you need to, and an assignment, assign the lease to the new buyer. Watch out for reoccupancy certificates. We discussed that. Some cities have those requirements. So we want to make sure if that is a requirement that that's applied for way early, because it takes time, especially right now during coronavirus. What they did is a lot of the cities are working on a skeleton crew, so they don't have their usual inspectors, and so a reoccupancy certificate might take longer than it would normally. So you want to make sure that you're proactive on that. Okay, success. Let's see. All right, so plan ahead. If you feel that there is an impending lawsuit, act immediately, call an attorney that you trust ASAP, develop your plan. By this time, you should already know what your insurance cover or doesn't cover, because I'm telling you, you need to look at your insurance right now. If your insurance covers certain things, they're always going to ask you to notify them. If you fail to notify them of an impending lawsuit, guess what? They're going to decline your coverage. So read your insurance to see what it covers, and read your insurance regarding their requirements for them to cover you. Okay? Whenever possible, if you have insurance, have them cover you, because that way they're paying for your attorney. You're not. Litigation is expensive. All attorneys will charge you per hour, and they're never going to be able to tell you how much it's totally going to cost, because it can go either way. It could be really litigated. You could enter into a settlement. Just don't know. Nobody can predict the future. So if you have insurance right now, go review your policy and see what it covers, understand it, and also understand what are the requirements for them to cover you. If you don't have insurance, why not look into it? It's better. It's good to have a plan. And then have an attorney that you trust, that you can, if something were to happen, you can discuss prior, you can discuss about litigation. You always need that guidance. You want to make sure. And somebody that understands about real estate. All right. Consider getting professional liability insurance, also known as errors and omissions. We've been discussing this will help diminish the financial liabilities burden of any possibility of a suit. Please, and understand what it covers. Very important. Another thing that I recommend is for agents to form a PA. A PA is a professional association. Now, yes, you can act under an LLC also, a PLLC, a professional limited liability company. But the state of Florida changed their laws in 2015, and a single member LLC, meaning an LLC with just one owner, doesn't offer as much liability protection as a professional association would. For you to operate as a realtor under a PA or an LLC, you have to be the only owner. Therefore, I don't recommend forming LLCs. I recommend forming PAs. PAs are corporations, but they are deemed professional associations because you're either a realtor, a doctor, a lawyer, a dentist, a professional. So only professionals can form PAs. The features are separate legal entity from these owners. You have limited liability, so only what the PA owns. And for real estate purposes, for commissions, that PA cannot own anything. It's only solely used to receive your commissions. So it has pass-through taxation if you apply for S-Corp status, which is what I would recommend. It requires a yearly board meeting and corporate minutes, so you have to maintain that. And it has personal asset protection. They will sue your PA, but they won't sue you personally. So why most real estate agents choose a PA is less expensive. DVPR allows you to change your individual real estate license into your PA. So for example, let's say your name is, I don't know, I'm going to use my daughter's name, Ariana Kilga. Then she can be a PA, but her PA name cannot be Fabulous Realtor of Miami. No, it would be Ariana Kilga PA. Why? Because that's what the law requires. And then her license will be under that name, and then her commissions would be paid to that commission. My daughter is 9 months, so she doesn't have to worry about that for now. Cost to create PAs, we think is less than an LLC, but it's the same. The IRS is more likely to audit LLCs and sole proprietorships than a PA. That's probably true. Also, you have more protection for things such as fraud, breach of duty, breach of contract, negligence, bodily injury, property damage, misrepresentation regarding the condition of the property, Consumer Protection Act. There's certain consumer protection laws that protect the clients. Earnest and escrow money dispute, misrepresentations regarding flooring, that should be flooding or leaks, misrepresentations regarding the value of the property. So you have a little bit more protection. So what do I mean by protection? Remember I told you that when you're in business, it's as if you're standing on I-95 and cars are coming at you. Well, by operating under a PA, you're able to basically put a stop to that, right? So you're stopping from them coming to you. I'm not saying completely stopping them, because if you use a PA as your piggy bank, your bank account, then you may not have fully stopped them, but you are stopping them from hitting you and limiting them to whatever your PA has, which would be your commissions, but you probably use them all up, so there will be nothing. We have a plan for PAs, for realtors. I can't recall the price right now, but I will send that to you. I'm going to send everybody a follow-up email. And in the follow-up email, it's going to include the pricing for the PAs. And if you guys are interested, we can help you. We have a flat fee, and it includes forming the PA, obtaining the tax ID, helping you fill out the form for the IRS for the S-Corp status so that you're not taxed twice, you're only taxed once. You will have to send out the form. We help you fill out the form for the DVPR so that the license comes out in the PA's name. We also draft your corporate documents, and we include your attorney's fees. Okay, so I will send that over to you guys. I'm gonna stop sharing my screen now and start taking questions. All right, let's see. If I, as an agent, have a close relationship to the seller, what do you recommend? How to best disclose? Oh, yes, very important. In your as-is contracts, if you are selling property or buying property, right? So it's your contract. You have to disclose it in your contract. You will see there is a little form that I can't recall the name right now, but there is a form there that you need to fill out regarding your relationship to either the buyer or the seller. Okay, so it could be your relationship could be that you are the buyer or the seller, that you have some type of ownership in the entity that is the buyer of the seller. You have to disclose if you're involved in that transaction at all. Okay, there is a form that you need to fill out, and there is a check mark in the as-is contract that you need to do. If you have any questions about this specifically in your particular situation, we can look at it together and see how you should disclose. But you must disclose, even if the property is not in your name, but you have a relationship, or you it's in a company name and you own an interest on it. You have to disclose. It's called agent interest in property, something like that. It's part of the things that you can check in the as-is contract, and it's also a form that needs to be filled out and signed. Don't assume that because your name is on, the MLS, that everybody should know that you're an agent. No, they're going to use that against you. So you must disclose, and the buyer and seller must sign. Okay. Is there a seller disclosure for land? Is there? Might be. I would have to look into that. Send me an email and we'll look into it. The software, somebody's asking if I can share the kind of software that I use to share confidential information. I use ShareFile. Okay, that's what my firm uses. It's worked out for us. Feel free to look into other softwares, but that's the one that I use. I don't, I don't own anything in that company. I have no issues with them, but this is what we use. It's called ShareFile. See if you can use it as well. Do you have a closing checklist that you share? I have a closing checklist for my law firm and my title company when we're doing closings. It's not necessarily for the realtors to follow. Just work with a good title company and a good law firm. On lawsuits against brokers, not their sell agents. That's not true. When you file a lawsuit, it's going to be against the broker, 100%, and against the agent too. Okay, so both. You're going to sue as many people as you can. That's the way it works. You're going to see who has the deepest pocket. So it's not just against the brokers, it's against the brokers and their agents. As a broker, when providing information to new agents as to receiving commission statements, is the agent required to register the entity name PA, LLC, PLLC with DVPR? Are brokers required to pay the agent in the entity name, or can the broker pay the commission in the agent's name? Okay. If an agent is operating under a PA or PLLC, that means their license, it's going to be named under that PA and PLLC. That's what needs to happen in order for an agent to legally operate under a PA or PLLC. And then the broker is required to pay that PA or PLLC the commission. The agent cannot take the commission in a personal name anymore. If they're legally operating under a PA and LLC, the broker pays the PA or PLLC. It's very important. You have to go through the whole process, and we do it for you if you hire us to do it, where we fill out the form for you that you need to send to DVPR so that they will send you a license in the name of your PA. The law requires that your PA be your legal name. So my name is Romy B. Jurado. Romy Jurado. So my PA will be Romy Jurado PA. It cannot be, best attorney in town PA. No, not for real estate commission purposes. It would have to be Romy Jurado PA, okay? Or Romy B. Jurado, depending how they have me. When recommending a professional, such as an attorney, an inspector, or lender, what kind of disclosure or verbiage could be used to make clear that a third party and separate entity? I would probably put in the email something like, below are some professionals I have worked with, my clients I've worked with in the past. You are free to choose whoever you desire. Please interview him prior to prior to hiring them. Because something like that, let them know that, yes, these are people that work with my clients in the past, but they're free to hire whoever they want. Please interview them. Please talk to them. Don't just make the decision based on your representation. Send them an email about that together with your list of people and let them decide. So somebody here says, somebody told me that the LLC gives liability protection. So is that not true? Okay, let me explain a little bit about that. In 2015, the law changed in the state of Florida. Basically, if you're a single member LLC with just one owner, and somebody sues the LLC, okay, they're able to force the LLC to foreclose on whatever property it owns. To give you an example, because there's only one owner, they can go and get the property. It's very easy. Whereas if that LLC has two members, then they cannot do that. They simply have the right to receive the profits of the LLC or whatever, depending on their judgment, but they cannot go and force the LLC to sell and do stuff like that. So that is why we're saying that in your scenario, for example, you're only allowed to have one owner, right? You can own the LLC or you can own the PA 100%. For those purposes, I advise you to have a PA instead of an LLC. For other clients that are doing other types of businesses, I advise them to add another member to the LLC. Maybe give somebody you trust, family member, whatever, 1%. So that way you make it a multiple member LLC, and then you have more liability protection. So that is why. So it's not that the LLC doesn't give liability protection. It's just it has changed a little bit, okay? For single member LLCs. How would it work if I'm a broker associate and work for another brokerage company and wish to become a PA? In a year or two, I want to open up my own brokerage company LLC. Is that easy to change or switch? Okay, so as a realtor, you can operate under your PA. When you become a broker, that's a separate story. You need to open up a separate company when you become a brokerage, okay? So as a realtor, you can operate under a PA, as a broker associate under whoever you're working for. And then in the future, when you want to open up your own brokerage, we set up a separate LLC for your brokerage ownership. And there is absolutely no way around for the agent not registering the name under a PA or PLLC. No. If you want to operate under a PA or PLLC, it has to be under your legal name. That's what DBPR requires. Brokers aren't allowed to form a PA. That is correct. You have to open up an LLC and or a regular corporation. It's a separate requirement. All right, let me see if I have anything under the Q&A. 1 second. Okay, it says, somebody here says that they have a mom, 92 years old, very sick. I'm very sorry about that. I have to leave now. Can you say, oh, they just want the PowerPoint. Oh, I'm so sorry. Yes, we will send a PowerPoint to everybody that registered. I'll send a follow-up email either later on today or tomorrow with the PowerPoint so that everybody can have access to it. Who do I recommend for insurance and what is the cost? I don't recommend anybody for insurance. You have to do your research, find different insurance brokers, talk to them, see what they offer. The cost is going to depend on the coverage, like everything in life. The more you protect it, the more it's going to cost you. Read the policy, because it's not about the agent that sells you the policy. It's about what the policy says. So you have to do your own research. I don't recommend insurance companies because I don't want to assume that liability. Because when they don't cover you, you're going to come after me and say, Romy, you told me to buy that insurance. Nope. Get the insurance, read the policy, hire an attorney to review your policy if you don't understand what it is. And then you need to make a determination. Do I pay more for coverage? Do I pay less for coverage? Do I understand the risk? That's a decision that you have to make. All right. If you have a seller who is listed with a 1% agency, okay, let me see, puts you in a position to respond to questions you've addressed to their agent. What is the best one? I'm not sure I understand this question. If I have a seller who is listed 1% agency, puts you in a position to respond to questions that should be addressed with their agent, what is the best way to handle being put? Oh, okay. So you're referring to those brokerages that have limited representation, to where the seller basically just lists the property with them, but they don't want to answer any questions. Okay. I'm not, okay, it says I had a situation recently that the seller signed an as-is contract, but offered to pay certain large dollar repairs, but not little ones that equaled a large figure he offered. If you are not representing the seller or the buyer, you shouldn't be answering questions for them. Point them to hire an attorney. Simple. Limit your liability. You know, if you're not their agent, don't act like their agent. You're not being compensated as their agent. Tell them they need to hire a lawyer. Sorry, people need to pay for professional service. So brokers cannot operate under their own PAs for themselves. FYI, they need to have their own companies. Okay, let me see. When using LOI on commercial property and it's accepted, does your company revise or write the contract? Yes. We draft LOIs, letters of intent, for commercial property, to buy it, to lease it, to do whatever you want with it, to buy businesses, to sell businesses. We also draft, We also draft purchase agreements, you know, regardless of the transaction, a simple commercial property that you're buying, a huge commercial property, development, all that stuff. Be really careful drafting LOIs for your clients. Your clients can draft their own letters of intent, but don't be the one drafting it, because now you're engaging in the unauthorized practice of law, and it can come back and bite you. So be very careful with that. Can I switch from an Inc. to an LLC? Can you switch a corporation to an LLC? Yes, you can do that. You can do a conversion. We can talk about it. And somebody's asking, in an LLC with husband and wife, is that considered two people? Yes, it is. For your commission, though, you have to be the only owner. However, if you're buying real estate, you're buying this, you're buying that through your LLC, you and your husband can own 50-50, 90-10, 99-1, and it's considered two people. So then you do have the liability protection. Okay, so whoever wants to do a conversion, just send me an email. We can discuss. We can send you our fees. Okay, I don't see any more questions in the questions and answer. I don't think. Do I have any other pre-recorded webinars? You guys can Google me, put Romy Jurado YouTube, okay? And I have all my recorded webinars in my YouTube channel. So what I'm gonna do now is I'm gonna put there my email so that everybody can reach out to me. And my phone number, my name, and here is one of my websites, my personal website. And I'm all over social media, so you guys can find me there too. And yes, I do have the YouTube channel, so you guys can look at all my pre-recordings there. Oh, somebody's asking me, what are the benefits or services of using my company for our transactions? Would you be the point of contact, or who do we contact for transactions? Okay, so through our law firm, we do real estate closings all over the state of Florida. We are attorneys, so we're able to solve issues, whatever may arise. For example, there's a code violation. We're actually able to go to the city or county and ask them to take out the fees or negotiate those fees and see how we can solve it. There's a person that died, right? So now you realize that your client is not really the seller, their dad is, and their dad died. So we're able to do the probate to get the order in order to sell the property as soon as possible. There is a pending foreclosure, right? So you realize your seller didn't pay the mortgage, or the association, now they're coming after them. We're able to represent them in the foreclosure, which from the from the condominium association or for the bank, to delay it in order to be able to do the sale. There is a tax issue that with the property tax, right? So the property tax, there's tax issue that needs to be solved. We're able to help with that. There are some rowdy tenants that will not leave your client's property. Okay, we're able to do the eviction in order to accomplish the sale. So what is the benefit? We're able to solve problems that through our experience, we're able to deal with them. We deal with foreigners a lot. So if there's any FIRPTA issues, we can solve them, plan them, or at least see what's the best way around them, or do a FIRPTA withholding certificate so that the money is not sent all of it to the IRS. We ask the IRS, how much do we really need to withhold? And then we only send them what we need to send. I have a great team. So I'm not alone. We're like almost 10 or 11 here in the office, and I oversee a lot of the aspects of the real estate that deal with foreigners and things like that. But my partner is the one that's really in charge of the real estate. However, if you need to contact me because of whatever, you could always feel free to contact me. I do have a fabulous team. We have a processor, a closing person, we do remote online notaries as well for foreigners too. So we're able to close wherever the persons are at. We do closings all over Florida remotely through the use of mobile notaries, remote notaries, mail-aways. So yeah, the benefits are we get things done. We're able to solve them. If we see an issue, for example, quiet title. This happens a lot, like they're not able to issue insurance because they bought the property through a foreclosure, through a tax deed sale. So that needs to be clean. We do that. So any issue that may arise dealing with the real estate, we can probably solve it. That's the benefit. And we're very good at what we do. We've been doing it for quite a long time now. I've been an attorney for over 10 years as a licensed Florida attorney, but I started in the legal field since I was 16. My first job was in the legal department of Bacardi. And I loved it. This is my dream. I always wanted to be a lawyer. And now I run my own firm and I love it. So I love what I do. And that's what I bring to whatever transaction or deal that we're handling. And my team is extremely responsive, because if they're not, then they can't be part of my team. We're fully bilingual and we're here to help you. I think that's the end of the presentation. We do planning for foreigners. Yes, we do. And somebody's asking if I do planning for foreigners who want to buy property here. Absolutely. We also help them with the visas if they want one, or if they just want to plan. Somebody says, oh, somebody's sold. Okay, great. Yes, use us. So anyway, thank you so much for attending. We have a crazy thing that's going on with the corona. It seems that it's coming to an end. I'm so excited. Somebody wanted to say hi to you guys. So I'm just going to have her come in. This is Foxy. She's my office pet. She just wants to say hi and wish you all the best. Thank you so much for being here today. Talk to you guys soon. Bye-bye. Roof, roof.